All right, good morning. I'm Deborah Wall. I'm the Deputy Archivist of the United States, and it's my pleasure to welcome you to the second annual open meeting of the Office of Government Information Services, or OGIS. Whether you're here in the William McGowan Theater at the National Archives in Washington, or whether you're joining us on YouTube. Congress directed OGIS to hold an annual open meeting as part of the FOIA Improvement Act of 2016. This annual meeting is an opportunity for OGIS to inform the public about its reviews and reports and to receive public, oral, and written comments. It's also a great opportunity to highlight the service OGIS provides to the Freedom of Information Act, FOIA, requesters, and federal agencies, and to talk about how OGIS has a natural home within the National Archives and Records Administration, or NARA. Making access happen to our nation's records and connecting with our customers are two of the four strategic goals in the National Archives strategic plan. OGIS's work as the FOIA Ombudsman helps to support and amplify our work towards those goals. With NARA's support and encouragement over the past 9 years, OGIS has built a robust dispute resolution and compliance program. Through these programs, OGIS provides valuable assistance to requesters and agencies by preventing and resolving disputes in the FOIA process, and by identifying procedures and methods to improve FOIA compliance. As the FOIA Ombudsman, OGIS also plays an important role in educating the public about the FOIA process. We appreciate your interest in OGIS's work, and I know that OGIS staff looks forward to hearing from you and reading the comments that you submit. I'm also pleased to welcome the four members of the 2016-2018 FOIA Advisory Committee, who will be discussing the committee's final report and recommendations to the archivist, and I look forward to hearing their discussions and their insights. I'll now turn the program over to Alina Semo, the director of OGIS, to provide an update on OGIS's activities during this past fiscal year. Thank you.
Good morning, everyone. Once again, we have that bright spotlight right there. It's become my friend. Thanks again for joining us on a rainy Friday. I feel like we're all going to drift away pretty soon. We've had too much rain, but I'm happy to welcome everyone here today at our second annual open meeting. We are very pleased that Congress has given us the opportunity to provide an update and review of our reports in our office and to allow interested persons to appear and present oral or written statements. This is a perfect forum to showcase all the great work that OGIS has been doing. We have reserved time at the end of our session today to receive public comments. For our web audience, we are monitoring the chat on live stream, and a member of the OGIS staff, Kirsten Mitchell, I'm going to call her out, but thank you for filling in, will try to summarize any substantive comments we receive via the chat during the public comment portion of our agenda. You may also submit any written comments to our email box, ogis@nara.gov. Before I launch into our review reports and other activities during fiscal year 2017, I want to take a minute to introduce some of the OGIS staff that is able to join us today. Ask them to please stand up and wave, just to put them on the spot. Amy Bennett is floating around somewhere. Hopefully she'll come back and I can reintroduce her. Kirsten Mitchell, our compliance team lead, is monitoring our live stream. Our newest mediation team member, Dwayne Bacon, is here. We're happy to have him. Our mediation team lead, Carrie McGuire, is watching via YouTube. Unfortunately, mediation team member Krista Lemelin is unable to be here today, and as is our staff assistant, Teresa Brady, and our attorney advisor, Sheila Portanovo. But there's Amy. I'm going to make her wave. Our deputy director position is currently vacant, but we hope to be able to fill it before the end of this fiscal year. I am pleased to have the opportunity to outline our fiscal year 2017 work with you all today. Our annual report is available on our website. I'm going to begin today by discussing our dispute resolution program, including the increased demand for our services. I will cover our fiscal year 2017 compliance work and highlight the trends we are observing. Next, I will discuss outreach and collaboration efforts and the development of recommendations to improve the administration of FOIA by the FOIA Advisory Committee. I will then talk about how our unique role in the FOIA process allowed us to identify and address requester confusion about the dispute resolution services offered by agency FOIA public liaisons and OGIS. I will then wrap up by talking about our expectations for the coming year. After my presentation, I will invite our panelists to the stage to talk in much greater detail about the work of the FOIA Advisory Committee this year. After the panel, as I mentioned earlier, we will open the floor for public statements. As most of you know, we have experienced a dramatic and sustained increase in demand for our dispute resolution services since enactment of the FOIA Improvement Act of 2016. Our new prominence throughout the FOIA process, particularly in the earlier stages, benefits us by giving us the opportunity to better understand a wider range of agency policies and practices and the interaction between agencies and requesters throughout the process. To handle the influx in requests for our assistance, we adopted an all-hands-on-deck approach, and we streamlined our processes. As a result of our team effort, the OGIS staff was able to close more than double the cases in fiscal year 2017 than in fiscal year 2016. Unfortunately, as you can see in the second chart on the slide in front of you, we are not able to provide some requesters, particularly those who have complex issues, with assistance as quickly as we would like. If you are interested in the status of our dispute resolution program, I encourage you to look at the quarterly customer service performance metrics posted on our website. And as you will see from the metrics posted for the first 2 quarters of fiscal year 2018, we continue to see a sustained increase in requests for our services compared to before the passage of the FOIA Improvement Act of 2016. We have also shared that we have put systems in place that are allowing us to respond to more simple requests for our assistance in a timely fashion, but our backlog of cases more than 90 days old continues to grow. We do expect that implementing additional strategies will help us begin to reduce our backlog in the coming quarter. OGIS has offered free dispute resolution skills training for FOIA government professionals since March of 2010. We continue to provide training biannually to help agency FOIA professionals prevent and resolve disputes without the need to involve OGIS, and we are more in demand than ever. Our training program on dispute resolution skills for agency FOIA professionals is extremely well regarded and in demand. In fiscal year 2018, registration for both sessions filled up within 24 hours of their announcement. We are also providing agency-specific training sessions at the request of various agencies, including NARA, our parent agency, as well as the Department of State and the U.S. Citizenship and Immigration Services. We have a number of events already on our schedule for this fiscal year, including several agency-specific dispute resolution skills training sessions, but our dance card is never too full, so we welcome any other interest from any other agencies. Moving on to our compliance program, we had a very busy fiscal year 2017. We completed agency FOIA compliance assessments of Immigration and Customs Enforcement, the Consumer Financial Protection Bureau, and the Department of Homeland Security Chief FOIA Officer. Our assessments of ICE and CBP followed our usual methodology. We reviewed agency materials, including written policies and procedures, interviewed agency FOIA professionals, and assessed a sample of case files. We then made targeted recommendations with the goal of improving the FOIA program's performance. Our assessment of the DHS Chief FOIA Officer was slightly different. While this assessment was also based on a review of policies and procedures and interviews, we measured the performance of the DHS Privacy Officer, who serves as the Chief FOIA Officer, against the Chief FOIA Officer's statutory obligations with respect to implementation, oversight, and customer service. We are also very excited that fiscal year 2017 marked the beginning of a great collaboration with NARA's Chief Records Officer through our participation in the annual Records Management Self-Assessment. The 2016 RMSA included FOIA questions and allowed us to gather near comprehensive data about FOIA policies and procedures from virtually all of the 117 agencies subject to FOIA. Agency responses to these questions created a great baseline for our understanding of the relationship between FOIA officers and federal agency records officers, and for the systems agencies do or do not have in place to identify information that could be proactively released. The questions and responses to the survey have also furthered our perspectives on observations in our agency compliance reports using program management, use of technology, and communication with requesters. Which leads us nicely into a short discussion about our compliance observations generally. We recognize that there is no one-size-fits-all to administer a FOIA program. Each agency's records are unique, and as such, management of record keeping and record retrieval processes are going to differ. However, we have consistently noted that good FOIA programs generally share three characteristics. One, they properly manage the resources they have. Two, they use technology effectively. And three, they communicate well with requesters. In terms of management, our assessments continue to show that good management practices, including having clear standard operating procedures and performance measures, helps improve performance by ensuring staff have a clear understanding of their roles and responsibilities. We have also observed that strong leadership and interest in the FOIA program contributes to the program's success. And we have also observed that investments in technology, including technologies to improve tracking and powerful e-discovery tools that deduplicate records and allow processors to have informed discussions with requesters about the scope of the request, have helped agencies reduce their backlogs and respond to requesters in a more timely fashion. We have also observed that agencies use their technology in the FOIA process successfully when they have sufficient IT support and staff training. And finally, we note that improving the quality of communication with the requester decreases the likelihood of disputes and reduces the risk of litigation. Many of these changes can be made at a low or no cost to the agency. Since OGIS opened our doors, we have viewed commenting on agency FOIA regulations as an important component of our review of policies and procedures. Between passage of the FOIA Improvement Act of 2016 and the end of fiscal year 2017, OGIS reviewed updated regulations published in the Federal Register by 50 departments and agencies. In fiscal year 2018, we have reviewed 9 additional regulations, and we look forward to reviewing the remaining agency regulations once they are published. Moving on to our outreach and collaboration work in fiscal year 2017, we were very happy to be able to launch our website in May 2017. We joined the NARA family. The relaunch came with an updated URL that helps the public better understand our place within the National Archives family. And in addition to the fresh look, the back end of the website got an upgrade, which gives our new website better navigation tools and makes it responsive to mobile devices. We are always looking for ways to improve our website and encourage you to email us any suggestions at ogis@nara.gov. In fiscal year 2017, we also organized the second annual Sunshine Week celebration at the National Archives. We were very pleased to be able to share with our audience a conversation between the Archivist of the United States and the Librarian of Congress about the role of cultural institutions in open government. The 2017 Sunshine Week celebration also featured well-known advocates of the public's right to know, including Ralph Nader, discussing FOIA at 50-year anniversary of the Freedom of Information Act. And the audience heard from individuals who are using technology in innovative ways to open government. We also held our first annual open meeting right here in this venue, and we were thrilled to host a meeting of the Chief FOIA Officers Council in July of 2017. During that Chief FOIA Officers Council's meeting, agency personnel offered feedback on template language we developed in coordination with the Department of Justice Office of Information Policy, OIP, which alerts requesters to the availability of dispute resolution services as well as the availability of agency FOIA public liaisons and FOIA request service centers. For the meeting, we also organized a panel to talk about ways of improving customer service. The panel included OGIS's dispute resolution team lead, Carrie McGuire, agency FOIA public liaisons, and requesters. The panel was moderated by the director of OIP. Moving on to OGIS's recommendations to improve the administration of FOIA, as we reported last year, members of the 2016-2018 term of the FOIA Advisory Committee were very busy. We are very lucky to have 4 members of that committee join us today in just a few minutes. The committee brings together FOIA requesters and agency FOIA professionals to collaboratively identify the greatest challenges in the administration of FOIA and develop recommendations for the Archivist of the United States. At the end of fiscal year 2017, the committee was still in the process of developing and approving its recommendations to the archivist. And on April 17th, 2018, the committee was still in the process, concluded its work on April 17th, 2018, and we approved our final report and recommendations. The report, which is available on our website, includes a number of unanimously supported recommendations to improve the administration of FOIA, including a recommendation that OGIS publish an extensive list of best practices identified by the committee. We look forward to working with the archivist on implementing these recommendations. Before I move on to what's in store for the remainder of fiscal year 2018, I want to talk briefly about how OGIS's unique role in the FOIA process allows us to identify potential issues and how we can use our tools to address these issues. To illustrate this, I'm going to talk specifically about an increase in requester confusion about dispute resolution services offered by OGIS and agency FOIA public liaisons, FPLs. As you all probably know, the FOIA Improvement Act brought heightened visibility to the availability of dispute resolution services. Shortly after the law's enactment, we began to notice a large amount of materials and calls intended for agencies, but directed to us by accident. We identified the source of this confusion as unclear or imprecise agency correspondence with requesters. And in response, we took several steps. We helped better explain the role of OGIS and agency FOIA public liaisons in our social media and other forums, and aimed to reduce requester frustration by ensuring the efficient use of FOIA resources. When our dispute resolution team noticed letters that seemed particularly confusing to requesters, we directly contacted the agency to talk about how they could improve the quality of their communications. We also worked with OIP to develop joint template language for agencies to use in their response letters. And then, as I mentioned earlier, OGIS and OIP gathered feedback on the language and publicized its availability during a session of the Chief FOIA Officers Council in July of 2017. We also integrated discussion about the law's new requirements to alert requesters of dispute resolution services into our training sessions and stressed the importance of clear communication. We also created a 2-page handout that describes who we are and what we do. The handout includes a chart that describes the kinds of assistance we can provide versus the assistance agency FPLs are able to provide at various points in the administrative FOIA process. You can find this handout on our website by visiting the OGIS toolbox in the resources section of our website. We have shared it widely via our blog and on Twitter. And as a result of these combined efforts, I am happy to say that our dispute resolution team has noted a decrease in misdirected calls and materials. But we definitely have more work to do on this issue, and we look forward to exploring how other tools can help improve understanding of the process and promote efficient administration of the FOIA. Before I wrap up my presentation and we move on to our panel discussion, I want to give you an idea of what you can expect from OGIS for the remainder of fiscal year 2018, the next 4 months. If you can believe it, we're almost at the end. First, we have a number of public events coming up, and we hope you can join us. They're all going to be right here in the McGowan Theater. On July 19th, we will host the next meeting of the Chief FOIA Officers Council. On August 30th, we will host a forum on immigration records with U.S. Citizenship and Immigration Services and other agencies that work on immigration records. We are also already planning for the next term of the FOIA Advisory Committee, and we will kick off our new term with the first meeting on September 6, 2018, right here on the stage. June 1st is the deadline for nominations, and we continue to accept those, so please apply early and often. Be sure to check our regularly updated blog and follow us on Twitter for updates on these and other events. For our compliance program, our next report we expect to publish is our assessment of the U.S. Postal Service. We also expect to publish issue assessments similar to the report on the use of still interested letters that we released in fiscal year 2016. One of the benefits of issue assessments is that we look at policies and procedures from several agencies during assessment, which broadens our compliance footprint. Our first issue assessment will look at the quality of agency correspondence, notifying requesters of the availability of dispute resolution services. I'm also very excited to talk about the rollout of an educational vehicle we are calling the FOIA Ombuds Observer. Hopefully you'll think it's a catchy phrase. We certainly did. and OGIS advisory opinions. Education about FOIA is a critical component of our work as the FOIA Ombudsman and is one of many key strategies for avoiding unnecessary litigation. The FOIA Ombuds Observer will address a variety of FOIA-focused topics based on questions we are receiving frequently and repeatedly from our customers. Since our creation in the Open Government Act of 2007, OGIS has had the authority to issue advisory opinions. Prior to the FOIA Improvement Act of 2016, however, this authority was tied to the resolution of a particular request for mediation services. For several years, OGIS struggled with how to reconcile its authority to issue advisory opinions with its ability to be an impartial party that can facilitate the resolution of disputes between requesters and agencies. OGIS intends to utilize this now modified advisory opinion power to issue opinions that address the most common disputes, complaints, and trends that we uncover through our dispute resolution practice and that are most likely to lead to litigation. Our plan is to build a body of advisory opinions available online for both requesters and agencies to consult that will help head off disputes before they fester or lead to litigation. Thank you all for your undivided attention and continued interest in the work that we do to improve the FOIA process. While I'm wrapping up my presentation, I would like to ask our panelists to start drifting to the stage if they're mic'd up. I have put our information on the screen so you know how to contact us in a variety of ways. And I ask that you hold any questions until the end. We have reserved time for public comment following our panel presentation. Again, you can also email any statements or comments to ogis@nara.gov, and our live stream viewers can submit comments using the chat function. We do have a member of the OGIS staff, Kirsten Mitchell, monitoring, and she will summarize and share any substantive comments we received during the public comment period. Thank you. All right, no breaks for anyone. We're going right into the next event. So I want to very much welcome, very heartily, 4 of our 2016-2018 FOIA Advisory Committee members. All 4 of them worked very hard, as did everyone else on the committee. But they were kind enough to join us today so we can continue to spread the good word of all the work that we did and start publicizing a lot of the great recommendations that we've made to the archivist, as well as a number of best practices that we would like to widely disseminate. So I'm just going to briefly give a bio for each one of our members, and I think we've kind of worked out a little bit of a order in which everyone will talk about a section of the report. We're going to try to make this pretty loose and open. We will welcome questions at the end, or perhaps during the middle of our discussion if you just can't wait. So first, to my very, very right, but your left, is Tom Sussman, who is the Director of the Governmental Affairs Office of the American Bar Association, a position he has held since 2008. He joined the ABA after 27 years as a partner in the law firm of Ropes & Gray. And before that, he was chief counsel to the Senate Subcommittee on Administrative Practice and Procedure and held other government positions. Tom's involvement with FOIA began when, as a member of the Department of Justice in 1968, he advised federal agencies regarding the new law. If I dare say, sometimes people refer to as the grandfather, I should say, of FOIA, which is an honor. I think you should take that as an honor. So he was there from the very beginning. In a Senate position, he was a principal staff lawyer for enactment of the 1974 FOIA amendments. Should I continue with her bio? I will just end with Tom holds a BA from Yale University, a JD from University of Texas School of Law, and he was an editor-in-chief of the Law Review at Texas. Sarah Kotler is the director of the Food and Drug Administration's Division of Freedom of Information. Since joining that division, Sarah has overseen a 70% reduction in FDA's FOIA backlog. It's really impressive, improved processing efficiencies across the agency, increased the number of records posted proactively, and worked with the requester community to improve the FDA's FOIA program. Prior to joining the Division of Freedom of Information, Sarah was an attorney with the FDA's Office of Chief Counsel and an attorney in private practice. Sarah holds a BA from University of Pennsylvania and a JD from Harvard Law School, where she was an editor of the Harvard Law Review. Sean Moulton is joining us as the current Open Government Program Manager at POGO, where he oversees the effort to develop a blueprint to build a more open and accountable administration. Before joining POGO, Sean worked for over a decade on transparency and government accountability issues, with special attention to FOIA issues, spending transparency, and environmental right-to-know policies. He has authored many reports, testified before Congress, submitted comments on proposed regulations, and helped launch public disclosure websites. Sean has led the Center for Effective Government's open government work for 13 years, and he has also worked at Friends of the Earth, the EPA, and the Council on Economic Priorities. You've been everywhere. In 2011, Sean was inducted into the Freedom of Information Hall of Fame, as was Tom. That was part of your bio that you let me skip. You were inducted in 2007, so that's quite an honor. Sean holds a BA from Albright College and a Master of Public Policy from the University of Maryland. Go Terps. Yep. Logan, to my immediate right, your left, is an attorney advisor currently with the Office of the Chief Counsel, Foreign Assets Control, OFAC, at the Department of Treasury. Logan previously served as intelligence counsel for the Office of the General Counsel at the Department of Homeland Security, where he provided legal advice and counsel regarding the department's intelligence enterprise and information safeguarding efforts, including FOIA and Privacy Act requests related to the department's intelligence activities. He also previously served as assistant counsel to the Inspector General at DHS, where he worked on FOIA and Privacy Act litigation matters. Logan holds a BA from the University of Florida and a JD in National Security Law LLM from Georgetown University Law Center. Okay, so thank you for allowing me to read that. I appreciate it. And I think as we talked, Tom, if I may let you have the floor first, you were going to share with us some insights about the proactive disclosure work that the committee has done.
I will indeed. I do want to start by saying that it was, for me, very exciting and an honor to be part of the Federal Advisory Committee. As Alina said, it's remarkable that a group equally divided between government participants and public sector requesters, media, business, not shrinking violets, any of us, and to reach a consensus at the end on some consequential recommendations, I think is remarkable and an accomplishment I think we're all quite proud of. Just to tell you how we got to these various subcommittees for a brief background, the advisory committee met on this stage. We were all sitting around a U-shaped table, and we started by trying to brainstorm what are the issues that we should be addressing. I think Amy Bennett brought out a whiteboard, put it up here. We all had Post-its, and people sort of went up and put, what are the issues? And we had lots of different issues. Early on, we sort of decided we wouldn't look at legislative proposals, in part because that was less likely to be fruitful given Congress's remarkable track record of legislating these days, but also because Congress had just finished a FOIA reform bill the year before and was unlikely to revisit it quickly. And it turned out from those, collating the various results and putting together the summary of where we wound up, the three subcommittees emerged: proactive disclosure, search, and basically, I guess, efficiencies in administration. And I was on the proactive disclosure subcommittee. And in some ways, our work was a bit like the full committees in terms of choosing our issues. We started with a pretty obvious one, and that is Section 508 of the Rehabilitation Act. And I say pretty obvious because the previous Federal Advisory Committee, a two-year committee on which I did not serve, struggled with the issue of proactive disclosure in Section 508 and reached no conclusion. And so we thought, well, let's give it another try. Perhaps we would not succeed. Perhaps we would have some possibility of moving the ball forward. So that was one of the important issues that we took on from the first meeting. And then the next step was to figure out, okay, fine, we've got this issue, and I'll come back to what the recommendation was. But what else? Where do we go with proactive disclosure? And the answer is, well, let's try to be very specific, very practical, give agencies something they can work with. And so, not unlike the whiteboard with the Post-its, we began the process of surveying the communities out, the nonprofit groups, advocacy groups. What do you think should be proactively disclosed? And I was running through my folder in preparation for this. We got lots of different charts and emails coming in, that said, here's one: communications with Congress, FOIA logs, visitors logs, Federal Advisory Committee information. One thing after another. OGIS had made recommendations to agencies about categories of records that included significant online records released under FOIA, reports to Congress. I mean, we had a long list, and a spreadsheet was set up. And again, we went through the process of, okay, let's try to figure out some criteria so it's not just totally so it doesn't look totally subjective. And so we came up with a list of things that we thought, for example, would a large amount of redaction be necessary? Would it be highly burdensome on the agency? Or is it very useful to have this information public? And we went about this process, and members of the Subcommittee on Proactive Disclosure voted. And we had some that were obvious that, yes, of course, we should include. We had some that were eliminated pretty quickly, like Office of Legal Counsel opinions. Well, that's agency-specific, engaged in litigation, so off the list. And we struggled with some in the middle, and I'll get into more detail. All right, so let me get to specifics. Section 508. It turns out that it's a problem, and everyone on both sides recognize it's a problem because you have potentially conflicting laws. You have the Freedom of Information Act saying, make this public on request unless there's an exception, and then you have not an exception statute, but a different regimen completely that says when you make information public, when you post information, it should be accessible to the disabled. Okay, so what happens when there are information that the agency should be posting, but it's not accessible? Or worse yet, what happens if it's already up on the web and not accessible? Now, case law didn't help. We had a presentation from the Access Board, not terribly helpful. We did some research on the subject. We surveyed various agencies and concluded that the one key to striking that balance was language in Section 508 that said, we're making this information accessible is an undue burden on the agency. Not defined, but an undue burden, then the agency does not have to make it accessible to put it up or leave it up online. And so we focused on the undue burden standard. We were cautioned not to try to give legal advice to the agencies by, Sean and I are smiling, I think those of us in the requester community would like to have perhaps put our finger on the scale and push down towards more disclosure despite the lack of accessibility. But the law was fairly clear that undue burden is a test. And so we leave it to the agency by agency. We leave it to general counsels to make determinations of what's an undue burden. But we stress, don't take information down to make it accessible. That issue came up perhaps in the last year in one of the agencies. If you've got a large quantity of information, one of our members was a historian at George Washington University, very concerned about historical documents that would have taken a lot of effort and energy to make accessible. Put them up, leave them up, let the public know that there are, if a person who is sight impaired would like access, they can contact the agency, and then remediation can be done on a specific basis. So I thought we did a pretty good job of providing some assistance to the agencies. On the subject of the long list, you can read, and I definitely urge you all to go to the report and look at it. It's got, unclassified agency reports to Congress, organization charts and directories, records schedules, statement of administration policy and enrolled bill memoranda, FOIA logs, one thing after another. And then when we got through with that list, we tried to capture our criteria. And so we put best practices, identifying categories. The ones we identified clearly don't represent the full universe. And so consider whether routine activities that are useful, whether it has legal effect, would be important regarding enforcement, whether redaction is needed, does it lead to an understanding of the agency's activities, especially in the enforcement area, consumer choices and information. Lots of very good criteria that when an agency is trying to decide, is it worth doing this or not, it can make that decision. One of the issues we spent a lot of time with are FOIA logs because we understand that technology sometimes can be a problem with that, but we do believe that those are important information to provide the public. One area that did not get a consensus and wound up on a compromise, and I'll end with that one, is the issue of agency staff directories, contact directories. And interestingly, in some of the earlier reports, it's clear that there are at least a half dozen agencies and some major departments that have their full employee directories that is with contact information available to the public online. And in the early days of FOIA in the 70s, I remember there was some litigation over the Defense Department directory. And the plaintiffs tend to win those because there was no consideration of a unreasonable invasion of personal privacy based on having a telephone number you can call to reach somebody in government who is being paid by, well, our tax dollars. On the other hand, there were agency representatives who felt that it was intrusive to privacy, that they had had discussions with some technology people who felt that the wholesale publication online of agency staff emails would facilitate spamming, spoofing, hacking, whatever. And their security people were very concerned about that. And so our conclusion was basically organization charts need to be public, and you have to have a window into each office so that you can contact somebody. And so the head of an office, the head, not just the department level and appointed officials, but those who have line responsibilities for serving the public, you need some way to get in, and it doesn't have to be 100% of all the staff. And that was our conclusion, that was a compromise, and it worked well. And in the end, the subcommittee unanimously made a set of recommendations to the advisory committee, and they're all in our report.
Great, thanks. Sean, I saw you nodding a lot. Is there anything you want to add to?
Well, I was on the committee. I think Tom did a great job of kind of summarizing both the process and there was a lot of common ground. I was impressed and I think encouraged that even people coming at the FOIA process from completely different perspectives, groups that want the information, and I wouldn't say groups that don't want you to have the information, but the ones that have to do all the work to get it for you, we found a lot of areas that we agreed on, and there were some contentious ones. There were ones that that didn't even make it through that kind of voting process that Tom was talking about. They were just seen as too burdensome and not enough benefit was another thing. We or there was some more obvious conflict, privacy, or something else that we thought would be difficult to get around in terms of a simple proactive disclosure recommendation. So,
great, thank you. So, Sarah, I think you're next. You're going to talk to us a little bit about efficiencies and resources.
I can do that, or was I just going to discuss what I thought was easiest for the
Absolutely.
Okay.
Yeah.
Well, in the report, let me back up for a moment. One of the 3 subcommittees, as Tom mentioned, was the Efficiencies and Practices subcommittee, and I was actually on the Proactive Disclosure Committee as well. But truthfully, in terms of my day-to-day as a FOIA officer, efficiencies and practices are very near and dear to my heart. So I was very interested to see what that particular subcommittee was able to do, and they use a very detailed methodology of collecting data. They actually crunched a lot of numbers, looked at what various agencies were doing, and came up with a group of agencies that they could, of different sizes, that they could get data and information from, and then conducted interviews and surveys with those agencies. And their specific recommendations are in the report. And I was personally pleased to see that I felt that my agency was already doing some of these. For instance, things like working with requesters early in the process to clarify and make sure that everyone is on the same page in terms of expectations of a request. Or things like making sure that people who work in FOIA in a particular agency can back each other up and maybe have different types of teaming structures so that you're not in a situation where if someone's unexpectedly out of the office for a period, the requester is left hanging. Those kinds of things. But then also at the same time making sure that people may be specialized in a certain area as well. There are very different ways that one can go about structuring FOIA offices. There were also practices involving how to best make IT decisions or things having to do with records retention. And so as a FOIA officer, my perspective that those were all very, very good ideas. But I think for most of us, it's easiest to implement ideas that are within our control. So for the way it's set up at my agency, the records department and the IT people, I am not part of their organizationally, and they're very helpful and nice people and want to help us succeed in FOIA as best they can, but FOIA is clearly not their mandate. So for me, the best practices in terms of communicating with requesters, how to organize FOIA teams, how to back each other up and specialize, those are the kinds of best practices that I can actually, if I'm not already doing them, I can do them tomorrow. I can make that happen as best I can and direct people to do them. Whereas practices about obtaining certain types of products, that's something a little outside of my area. I can try my best to make it happen. I just don't have control of that as part of the process. Or again, my IT people are wonderful and very helpful, but I can't always say, this is the way we're going to want to do it. We're going to want to post all of these things tomorrow and make them 508 compliant and get them up there tomorrow. So I think for me, that's what it came down to, and I know that to the extent that we aren't currently doing all of those best practices, I'm going to try my best to make sure we are, and I think we'll have more success like posting the FOIA logs. That is something that I believe that I can make happen, although it certainly does involve people outside of my immediate purview, whereas there might have been other recommendations that would be a heavier lift without someone championing the idea from another part of my agency. So.
Tom, yes.
Yeah, that really calls to mind something that keeps recurring as a challenge, and that is, which you mentioned, the FOIA, records management, and IT being in different silos in the agency. And at least you're talking to them, which is important. But for example, coming back to proactive disclosure, I mean, a lot of the challenges lie with the IT acquisition of platforms to be able to make these disclosures. And we've seen in certain examples, Justice Department, foreign agents registration data, that if the wrong decision is made, the information is really, can't readily be made available even from a FOIA request with ease, without reprogramming, for example. And so I think there is a message there, and perhaps one that ought to go down, we ought to make a note of for the future, of how to get the IT people more engaged at the front end with the FOIA and records retention people, because you also have with electronic records the same set of issues, which I now, as soon as I mention IT, I'm sort of going out of my depth because my age begins to show with my lack of familiarity with a lot of the technology, but I recognize the problem.
Sure.
So I want to jump in on, two things. One, on the 508 compliance, one of the real ironies we found in looking into this was that a lot of these documents were 508 compliant. They're inside the agencies and are 508 compliant in case the agency have people that need readers or things like that. And that in the processing of these documents to release them to the public, or to, I should say, to a requester, that 508 compliance is stripped away. If there are electronic records, the process by which they redact and make sure those redactions can't be undone basically strips away all the metadata and all the 508 compliance. And so they start out 508 compliant, and then in releasing them, we make them less accessible. And it was a true irony, and it was because of the, as Tom's saying, the IT systems that we had. That's how they worked. That is how they did that. And so it was one of the emphasis was to figure out a way to preserve, through that FOIA processing, preserve that 508 compliance in the future. And obviously when you kind of give IT people a task, someone's going to figure it out. And so I don't think this is an insurmountable challenge. It's just one that I think the IT community just hasn't really known that they needed to solve for government. But the other thing I wanted to pick up on, I was also on the Resources and Efficiency Committee with Sarah, and I did want to underscore that we dug through a lot of the FOIA performance data to try and identify agencies of sort of varying sizes, mostly large and sort of medium, that had done some great performance, either processed a lot or brought their backlog down over a period of years. And then we went to them and basically we're just kind of saying, how did you do it? What were the key steps? And for the different agencies, it really was a wide variety of things they did. There wasn't one magic bullet. It was a series of steps. Technology was definitely one of them, and that's a big theme through those best practices. Management of the process itself turned out to be more than a little bit critical, and that kind of surprised me. Some agencies aren't using sort of this multi-track still of complex requests versus simple requests. And some agencies have more than those two, and then there's expedited, I should say, 3 tracks. But some agencies use even more than that to help make sure that everything keeps moving and that the backlog doesn't get stacked up behind one big request that is going to take so long to process that nothing else is getting done. And so that kind of multitasking. I thought one of the really great recommendations we came up with in terms of staff that I thought was really exciting, and I think it actually came up during a general meeting, not one of our subcommittees. Someone threw out the idea, but it was the idea that maybe you could have an open contract for FOIA assistance to sort of bring on for a surge if you had a lot of requests, like the State Department did at one point, and other agencies have experienced. And you need to bring on people, but just for a short period of time, a few months, you want to bring on FOIA people. And the idea was either to have sort of an open-ended, indefinite delivery vehicle contract that any agency could tap into. So maybe GSA would run it, and that if you got into that situation, you wouldn't have to do a whole new contract yourselves and start that process, which could take months, if not more than a year, just to get done. You could just tap into and do sort of a delivery order off of an existing contract and get that personnel much faster.
I actually also really like that idea because we actually have looked into that in the past. Could we get some contractors to help out? And it turned out, well, we didn't have a contract vehicle. So that's something I would like to explore. And a related idea that you all came up with was to rotate program staff through some kind of FOIA detail. Mm-hmm. I think, number one, it would always help the relationship between the program staff and the people who are constantly asking them for records to understand that part of the process. But also, they then might be people who could help out in a situation where suddenly you needed some people to help out because of some unexpected issue. And you might find that, we've had people on the program side who it turned out really liked FOIA and got interested and said, hey, is this something I can get into? You might find some people who really enjoy it and maybe don't want to give up the position they have, but might be willing to do it on an as-needed basis.
And we were also thinking with that one that program staff really are so critical in finding information and preparing the information and that is eventually going to get searched. And if more program staff kind of understood what it takes to to find, process, and release information, it might actually change the way they manage their own information to just make it easier, and that message would start getting back to more of the agency, and thereby making the FOIA department's processing easier going forward. One of the things I felt like we didn't tackle, it was underlying everything we talked about, but it was resources. We were always thinking about how can you be efficient with the resources you have, but certainly one of the real challenges is, how much resources does an agency need? How do you prove that? How do you get those resources? And so we really focused on managing the resources. How much do you get and how much should you get? We kind of left as each agency is going to figure that out right now. But I do think it's one of those larger questions. If you're not getting enough resources as a FOIA department, you can be as efficient as possible, and you're going to still continue to fall behind. So I think that's one thing that I'd like to tackle at some point.
I'm writing it down as a great topic for the next term of the advisory committee, so thank you for that. Sean, were you going to talk about any other aspect of the report?
The other one that I wanted to bring up, it was, and I think it's going to lead into Logan's comments, it was about the technology. It kept coming up. I don't think there's a magic bullet out there in terms of technology, but there are some big pieces that would help agencies to manage their information. And there's sort of two different ways. There's the library of information that is being requested, but then there's also managing your requests. There should be, agencies should be figuring out better ways to do both. Better systems, that to manage requests coming in really would enable agencies to give people better answers, maybe even access to sort of online, sort of electronic updates on where their request is, how long it's going to take, the estimated time of completion. All that is out of their hands, and a requester can get that automatically. The other thing that was really great is that some of these systems actually enable you to track the number of pages that are being processed. And it turned out to be a real management tool at some agencies, that it wasn't just about closing a request. One person could close out 20 requests, but if they were very simple requests, it might be only 100 pages that they closed out. Another person might work on one request during that same time period, but process thousands of pages. And so coming up with that kind of common denominator of evaluating performance, and then using that to then figure out why were some requests taking longer, why were some pages harder to review than others, and then again, figuring out how you allocate your resources for future requests was interesting to me. But then I think the much larger thing, and we had presentations, I'll let Logan talk about this, but was about how do you more quickly find the information that people are requesting, because that in and of itself seems to be such a time sink for the agencies. And for many agencies, it's out of the FOIA department's hands. So I'll leave it there.
Great segment.
Perfect timing. So I co-led the search subcommittee, and I think we came up with 4 recommendations, and you'll see through 3 of them, technology is the driver, and the 4th one was more on the accountability side. Technology across all the committees, really, that we focused on, and same thing for search. We set out on an effort. We said we were going to identify the best FOIA search technology, and then we were going to pump it up and praise it and get everyone to adopt it. We tried to undertake that effort and couldn't even get past step 1, which is what technology are people using. We weren't able to actually locate any public information from every agency FOIA office on what they were doing for FOIA searches. And that became one of our main recommendations, was this information needs to be collected and published so that the public can use it, agencies can use it, it can be a point of reference, and then either this group in the next version of this committee or DOJ or some other group can go in and review all of the different technology and make recommendations about what's working best and how to get it more efficient for everyone. So technology, just again, based on everything everyone else has said, that was the biggest hurdle. Another thing that I think Sarah touched on, I mean, I think we saw a need for more interagency working groups, bringing the FOIA folks together with the chief information officers. That was one of our recommendations. Get these groups together. There are already working groups out there, but they need to cross-pollinate and overlap and bring the technology folks with the FOIA folks in so that they can come up with ideas together. Because you have a whole CIO council coming up on ways to modernize the federal IT system, and then you have a Chief FOIA Officers Council, which are FOIA officers from agencies working on how to improve the process and administration of FOIA throughout the government, but there's no overlap. They're not talking to each other currently. So that was one of our recommendations. And then the third one I'll talk about was really, I think we touched on the acquisition process as agencies bring in technology to carry out their missions, whether you're at the FDA worried about food and drug safety, or at my agency, Treasury, where we're worried about economic sanctions on foreign countries or foreign people. There's not a thought when we're procuring systems maybe about how to make that data retrievable for FOIA purposes. The agencies that I've dealt with and seen, we're very mission-focused, mission-driven. Our procurements are, what do I need to get the job done? And the FOIA folks aren't brought in on the front end to say, well, is there a way to search this by topic? Can I pull out information by person? Is there a way that members of the public are going to be able to access this? Is this information even exportable? Do I have to just print this database in code? I mean, how do we actually process this and provide it to the public? So bringing those conversations into the front end before systems are procured, our goal is not to really slow that down, but to make sure that those requirements can be fed in on the front end. And then the fourth thing that I want to just touch on is we identified a best practice that we were able to come up with and preach was really something that DOJ had implemented, which was FOIA performance standards for individuals that are responsible for FOIA searches. So in some agencies, FOIA search capabilities are centralized in a FOIA office that has great IT access and IT systems to go in and run email searches. In some, it's left. In some agencies, individual custodians who hold the records are required to go through their own records, or there may be like an office admin who's responsible for searching for the entire office. But the one common theme we found was these folks aren't being held accountable because it's not worked into their annual performance plans. And we thought, you know, if everyone in the federal government who's required to do a FOIA search is held accountable every year for how well they're doing their FOIA searches, we're going to see improved processing of FOIA searches because folks are being measured and graded against their capacity and willingness and ability to get those searches done, regardless of where they work in the agency. So we're hoping to see that implemented. You know, without the accountability, I don't think you're going to see the process improvements. But on the technology, again, I just want to point out, like, it's across all areas that we looked at: processing, getting the records, making them available, making them 508 compliant. Without implementing and incorporating FOIA technology and making it better and integrating it into everything that FOIA professionals do, you can't administer the FOIA, you can't meet the needs of the open government societies, the public, and it's even frustrating to the FOIA professionals who don't have the technology that they would like to be able to get the mission done.
Tom, go ahead.
Yeah, I want to also mention that when the issue is a search, the problems go beyond just the requester and that set of information being requested. And I think, thinking back, one of the reasons we focused on that as a subject for a subcommittee was the existence, for those of us who follow the law on this subject, so many lawsuits involve challenges to the adequacy of a search. So when you don't have a search that is efficient, broad enough, deep enough, a lot of these wind up going to court. And even when the agency prevails, often it, in the process, finds additional information, provides additional information. And I mean, I haven't done a study, but I would be willing to bet that a great deal of the government's litigation in FOIA cases and the cost of that litigation is due to challenges to the adequacy of the search in the front end.
And that's where there were some statistics a few years ago, Tom, and that's where the government loses their FOIA litigation, usually not on exemptions, but on adequacy of search, more often than not. It's over 50% of adverse decisions are because the searches are not proper.
So apparently I had mic issues. I don't know if you can all hear me now. So I heard Sarah talk a little bit about some of the things that are the easiest to implement from the committee's report. Can I turn that on its head and ask about what are the hardest, the most challenging ones that you think would be to implement? And I'm going to ask everyone to weigh in, so Sarah's not the only one that gets picked on.
Well, I'll say that those things that require financial resources are going to be the most difficult, and that would be technological issues the most. So that's always a challenge. I mean, that's across agency, and I think even those of you who are in the public, who are in the private sector or work at organizations know the challenge of resources, not just something that affects us in the government. Also, as I mentioned, the ones where we don't, as FOIA professionals, have control. I love the idea of having performance metrics or accountability in employee performance evaluations, and I'm very fortunate that some parts of my agency have done that. But that's really a personnel issue, and one that, while I can advocate it all day long and others can too, it's also not entirely within our control. But I am seeing a trend towards that, which is positive. So again, those things that we don't have as much control over, and those things that cost money. Now that said, I think that there are many things we can do in the FOIA that actually don't cost a lot of money and that are within our control. I think that every FOIA office needs to assess its strengths and weaknesses and say, okay, what are the things we can focus on that are within our control? Okay, one of the complaints we're getting is that, requesters aren't getting called back enough on their status updates quickly, and so you can say, okay, this is the rule. All calls and emails are going to be returned within 24 hours, and you're going to be evaluated based on that. That's something that doesn't really cost anything, and that I think would be fairly easy to evaluate people on. Either you're getting complaints that people aren't returning phone calls, or you're not.
Right. That's great.
So let me first say one of the easiest things to do, which we haven't talked about, and Sarah sort of intimated, OGIS does audits of agency of practices and makes recommendations on how to improve efficiency without additional resources. And I've looked at the summaries, and I've phenomenally useful stuff. In fact, so good that the Department of Justice said they should also do the same thing. And so I think that's really extremely important for agencies to understand that you're not in there alone. You don't have to pick up our report and try to figure out how to do it. And you can use OGIS that has been deeply engaged in developing all of these proposals and helping us shape the final ones so that they will be practical. And in that respect, I note that the recommendation is to the archivist, and in some cases, the archivist will recommend agencies, but in most cases, the archivist is telling OGIS, this is your responsibility to help implement. So that's the point. On the resources issue, Sarah, there's also the long-term, short-term. And this is not an agency problem. This is really, human nature, but also a Congress problem. Of not wanting to invest the extra money in technology that will take more than a year or two to justify its cost. And technology may not be necessarily the right place to talk about this because it changes so fast. But nonetheless, it does seem to me that a lot of these things that we've talking about are worth an investment because they will be cost saving. And that goes back again, I keep talking about OGIS, this is your forum. Part of those of us who were involved in advocating for creating OGIS felt that it would be money saving for the government, both in terms of preventing or avoiding litigation by the dispute resolution function and by saving the government costs by the efficiency advising function. And so both of those are long-term matters.
Thanks for the plug too. We really appreciate it. Sean, I think you were shaking your head a lot.
Yeah, I mean, I think Sarah and Tom are on the right track. I mean, with the anything that's going to require money. I mean, I guess I would focus in as frustrating as it will be to say this, but I think the 508 will be the issue that I think will be the toughest because it's it's almost certainly going to require money and technology to solve, but it's also going to require some sort of, legal opinion kind of decision on agencies' part, and there's a risk involved, as we've heard from others, and agencies are, and I don't mean to say this is a bad thing, but agencies are risk averse, and so they're going to be very cautious on this. And so as someone who wants them to do more proactive disclosure, and I don't want to see 508 become that impediment to it, it's frustrating, but I do think that this is one of those things that we're going to have to wait and see. I'm hoping these recommendations will move the ball forward a bit, but I still think there's a lot of uncertainty out there for it.
What about a legislative fix?
A legislative fix could be exactly what we need to clarify, as Tom said, exactly how to strike that balance. What is undue burden? They could solve a lot of the problems by clarifying that. Unfortunately, for the most part, Congress is risk averse as well, and they don't have the same lawsuit risk, but they have sort of a public perception risk of choosing between these two different things. They're both public goods in a lot of ways, and so you don't want to be seen favoring one or the you don't want to be seen as the one who's saying, well, I don't want to disclose more information to the public, and say that it's 508 compliance. If it's not, it doesn't go out. Well, you could come out looking badly on that. On the other hand, if you say, no, we want all this information out there to the public, well, now you're not taking into consideration people with disabilities, and you look like a bad guy again. So it would be great if that happens, but I'm not going to hold my breath on that.
That's fair. Logan, what about you? Hardest or easiest? You can
I'll
take
start.
either.
I'll start with the easiest, which hopefully isn't too cute. But I actually think every single recommendation in our 30-page report, it should be the easiest thing to implement. If we can get the outside, the members of the public to agree on those recommendations, members of large cabinet agencies, mid-sized cabinet agencies, OGIS and OIP to agree on 30 pages of recommendations, every agency should be able to pick up that report and figure out a way to implement something. And I think certainly in the best practices section, we didn't make those up. This came from case studies, examples, agencies we knew that were doing these things. So every single FOIA officer in every agency can pick up that list, look at that list. Maybe there's 30 things and 20 of them are too hard, but those 10 they can easily pick up and implement. There's resources, there's other people out there who have done this and can tell you how to do it and how to implement it in your agency. So I think it's doable. We've seen it be done. In terms of the hardest thing to implement, obviously money, change, I think legislation is hard to implement. I think we see Congress taking a very long time in between FOIA updates. Every time there's FOIA legislation, it tinkers with it. There's been no real wholesale changes overall to the structure of FOIA, which hasn't necessarily adapted with technology and the way records are being handled and stored by agencies. And I think maybe looking at ways to wholesale overhaul FOIA might be the hardest thing to implement, but might be the most useful to both the government and the public in accessing government records.
So I'd like to follow up on that because they do sound easy. Sarah made a comment that sort of reminded me of something from the ancient past. When you talked about you have a problem with FOIA officers just making phone calls to follow up on requests. And I mean, I recall, I think it may have been in the late 70s that I talked to a group from the American Society of Access Professionals as a requester on a panel and saying, the most important tool for you in carrying out your job isn't the photocopy machine. This was pre-computer days. It isn't the black marker for redacting. It's the telephone for contacting. And, that is a constant refrain from requesters. The Justice Department certainly all Justice Department guidance, all OGIS recommendations say, stay in touch. Our experiences, I'm sure Sean and I have the same experience where, I can give an agency lots of leeway. It took the FBI a year and a half to come up with a memorandum that I knew existed because I had seen it when I was on the Hill, okay? And so I could give them a lot of, and they just couldn't find it. Okay, that happens. Record retention and FOIA sometimes, but I got frequent calls back we've got a new place to look, Mr. Sussman, we're going to be trying this. I just understand that some of the things are out in, Stone Mountain or wherever, and we're going to, it's going to take us a while, but we're going to look there. And they came up with it. And I was very happy with the whole process, and I like the opportunity to applaud that publicly. By contrast, I had an experience with NIH that just, was missing in action. They didn't acknowledge receipt. I finally got hold of someone. They asked for, could I send a third copy in again? And it was so frustrating, again, on a fairly simple request. And so there's no question that those of us who often make life more difficult for the government FOIA offices can be mollified a great deal just by hearing your voice but saying, we feel your pain. We understand your problem. Do you understand how big this issue? I've had that before when I represented commercial requesters, businesses. The agency called back EPA, right? Do you realize it's going to cost over $100,000 of search fees? You want us to search for this information on certain chemicals in every office? And I said, sure, because if it turns out that you take a regulatory action that we see contemplated based on the information, it's going to put a number of companies out of business, and they're willing to spend $100,000 to determine whether or not that regulatory action is justified. And so we sat down and worked out a schedule and worked out payments and worked out, rolling disclosures. And sometimes it comes to that, but it all requires communication.
Right, and I think that's why it's important. Yes, there are these big intractable issues like 508 and general resources. And you have to focus on those sort of in one part of your brain. But then on the other side, you have to be like, okay, we need to be better at calling people back. And we need to be better at using things like email and other everyday technology to help us. Things like that. Make it easier for requesters to submit a request online. Make sure your FAQ, frequently asked questions on your website are up to date. Things like that. And that's really just not that hard to do. And it doesn't solve all the same problems, but it does help in some situations. In our high-tech world, I can tell you in the last few years, my agency has been sued by a requester who was simply upset that no one was calling them back. And I don't really blame them. I'm not happy that we got sued about it, but it was something that was entirely preventable. And that's something that it wasn't because of 508, it wasn't because of some complicated FOIA issue. It was because someone kind of wasn't getting what they needed from the program office and didn't know what to say and chose not to call back. And that's never a good result for us. So we shouldn't lose sight of the easy fixes while we're trying to work on the complicated ones.
Were we going to ask questions of each other? We have a few more minutes. I know I was going to also open up to audience questions. You can queue up.
Well, one of the things that I gave you a little fair warning. I do think that we ought to, that our National Archives and OGIS ought to, take an opportunity to look back at these recommendations at every 6-month period. I don't think it needs to be part of your new advisory committee, but to assess progress, to see if agencies need help on anything, maybe provide a little more attention to the technology issues, because the follow-up is important. And I say that, Alina knew this was coming, because the first advisory committee labored for 2 years, very smart people from both the agencies and the public sector, and came up with one clear recommendation that the archives request that Office of Management and Budget update the fee guidance, which was only, 20 years old, something like that, almost, not quite 20 years old. And that it went into a black hole. The archivist, transmitted the recommendation, and that's the result, the silence you hear. So, I think that we have a responsibility not to let that good work go to waste and to move forward, and I use that as a way of suggesting that it's maybe time for the archivist to ask the Director of Office of Management and Budget what happened.
Yeah, as we talked about earlier, we're very committed to continuing to get the good word out on this report. I know there was a lot of hard work that went into it, and we want to take every opportunity we can. Chief FOIA Officers Council's meeting is coming up soon in July, and we want to spread the word to all the FOIA officers that come and watch us on live stream. But I think Tom's suggestion of doing a check-in like every 6 months, I think is a great idea. Maybe the next committee can also incorporate that as part of their process as well. Sarah, looks like you wanted to say something.
No.
Oh, okay. You're just looking.
Yeah, very intense.
Yeah, I'll jump in and say, I don't want to put this all onto OGIS. I think I definitely see POGO getting involved. I think people on the committee have a responsibility to be advocates now for the recommendations we've come up with, and certainly POGO is going to do something around these and keep the drumbeat going. I also think OIP has been involved in both of the FOIA advisory committees, and they collect a lot of information. And this might not all rise to the same level of information they collect, on either their chief FOIA officer reports or the data reports that they do quarterly and annually. But some of it should probably make its way in there, either explicitly, are you doing exactly this recommendation, or questions more pointedly trying to get at the general ideas that these recommendations are covering. I think that makes sense too, and we should push OGIS to include them.
So on proactive disclosure, what about a baseline that someone, OIP, OGIS, NARA, would ask the agencies this summer, send the list of, the items are listed, they're in a grid, send them down. Which of these are you doing now, completely? Which are you doing partially? Do you have any problems with doing them in the future? Do you have a potential time frame for doing these in the future? And if the answer to any of those is no, why? Okay, and draw that as a baseline, and then we can come back and would have something to, some agencies, they're enough, it's sort of like the disclosure of staff contact information, that, it's hard, really. We agreed not to make that a big issue, not to fight to the death on that one. But when HHS does it, it's kind of hard to see why Interior can't. So having that potential for peer pressure, or at least peer comparison, might be a useful way of pushing the accountability. Use transparency to help move it forward.
Mm-hmm.
I think we won't see the change without the accountability that you're talking about. We've set the standard. We've said what the standard should be. I would encourage OGIS in their assessments of agencies to use that and assess agencies against those standards. GAO, inspectors general can conduct audits against these standards to see if agency FOIA programs are implementing them. Congressional subcommittees can conduct investigations of agencies they have oversight over and see if those FOIA programs are doing it. So I think we've laid the groundwork. There's standards, and now we need to see the implementation. Agencies need to be assessed against them, audited, and then held to account, because the committee, a 2-year ad hoc committee, can't do that. But when there's an old GAO report and agency heads are meeting quarterly or monthly with the head of the GAO, and they're saying, why haven't you implemented this recommendation from 10 years ago? I'm going to tell Congress. It gets attention and things get moving. So those are a few options I would put out there and encourage to happen if we could.
Well, and I appreciate the fact that we're not alone. So thank you for all the support. We have a very small staff, so we need all the support we can get. Any questions from the audience? Please come up to the mic. Maybe you can introduce yourself. Hello?
Hi, Rick.
Hello, I'm Rick Bloom. I'm with the Reporters Committee for Freedom of the Press. And I may raise this later in the public comment period, but I wanted to ask anybody on the panel, apart from interactions with OGIS, have you ever seen the Privacy Act as a barrier, either in the referral, consultation process? You developed 30 pages of recommendations. Was that ever a problem? Or maybe the answer is simple. I don't know.
That's an agency question.
A problem in terms of can you give us a little bit, like an example of what you're thinking?
Well, I'll give you one example. Was a news outlet submitted a FOIA request for a document that they knew existed. And that led to a leak investigation where they found the source. And I just wonder, the Justice Department says that if an agency gets a request in and it finds documents that are equities of another agency, they should go through that process, including giving that information, the request, information about the request to the other agency. It improves efficiencies, all those wonderful things. But with OGIS, there tends to be this position that you need to get a SORNS or you need to get a Privacy Act waiver. And, that's something that I wonder if, the standards are the same.
I could just speak from the OGIS perspective, and this is something we, advocated when I testified in front of the Senate Judiciary Committee back in March. It's a concern for OGIS in terms of our dispute resolution program, and we don't have SORNs with certain agencies. When we get a requester who comes in to ask for our help, we need to ask them for a privacy waiver in order to advocate on their behalf with the agency. And then in our compliance program, it's also an issue, because if we go and assess an agency with which we do not have a SORN, when we ask to look at a sample of 500 case files, we've got to go and ask each individual subject of each case file for a privacy waiver. Seems very unrealistic. So I know that's been a continuing issue for us, but I don't think it's something that really kind of came across from the agency, from the committee's work.
So
we didn't
nobody else
encounter
has
it.
seen this come up in other parts of the FOIA process? Okay. All right.
No.
Thanks.
But we'll think about it for the next term. So thank you for asking the question. Hi.
Hi, I'm Virginia Burke from the Peace Corps. Recently in my new position, I'm a FOIA liaison as well for the agency. So I'm going to ask in front of everybody, because I am handling a case that was appealed. It was a Privacy Act / FOIA. And in the course of the case, not to get complicated, but it became an investigation for other means. So as part of the appeal, we're explaining to this person for FOIA, he has the right to contact OGIS. We explain under B7A, but be aware for privacy concerns, and we cite the privacy exemption, but please be aware that for privacy concerns, OGIS does not support that. So for FOIA purposes, yeah, but is this requester allowed to come to you purely from a Privacy Act interest? I want to make sure, as I'm working with him, that I'm properly guiding him.
Sure.
So I'm asking in front of everybody, in case everybody else knows this, I thank you for enlightening me.
Well, I'm going to wait for my OGIS staff to correct me, but I believe the answer is we do not handle pure Privacy Act requests, but if it's a mixed FOIA and Privacy Act issue, they are certainly welcome to come to us, and we'll be happy to work with them.
Sure. Well, aren't most requests that aren't routine for forms, for example, something like that, likely to be mixed, or they should be
Yes.
mixed? I mean,
Yes.
back when I was making a lot of requests, you would always mix them because you get the time limits of the FOIA and the Exemption 5 information from Privacy Act. So from the requester's perspective, you get maximum benefit out of the law by having it mixed. And I'd hate to see that cause a problem with disclosure, because it's supposed to facilitate disclosure.
We are required to process under both.
Under both, exactly. Anyone else have any questions?
Hi, Sharita Gruberg with the Center for American Progress. I just want to second the emphasis on staying in contact with requesters. It helps so much. But also I had a question about kind of the submission process. I've noticed that on the IT side, agencies have tried to set up different platforms to varying degrees of success. I think the common element is none of them really work very well. HHS's is consistently crashing. HUD's magically loses account information and deletes accounts if they aren't used in some undetermined period of time. And my favorite is the Air Force's basically only works if you're on a DoD server, which was amazing to discover. So I was wondering kind of what work is being done with the agencies to improve these platforms.
Well, I'm not sure I'm in the best position to answer that, but there's a big rollout of the National FOIA portal by the Department of Justice. They worked in conjunction with OMB to get that passed, and I think the hope is that all of these agency portals are going to become compatible in some way, and I'm going to show my age just like Tom did. I don't know all the intricacies of the IT lingo, but they're all supposed to be interoperable. I think that's the right word we're supposed to use. But we're just getting started. So I know we've heard from requesters that have that concern with different agencies, with servers that go down and they're unable to even lodge a FOIA request. So we're definitely aware of that. We keep trying to spread the word, and I know Department of Justice is working actively to try to fix those problems as the next iteration of the portal goes forward.
Thank you.
I realize it's not perfect.
Thanks.
Yeah, and sometimes things are blamed on technology that can be resolved by talking too. I mean, I had a request for a database at the Justice Department that finally had to go to court before we won. But the Justice Department kept saying, well, there are fields that are non-disclosable. And we kept saying, well, identify those for us. And we have, I represented a client at a university with a very good IT department who worked with them. And our smart people could talk to your smart people about how best to get the information out that we want. And absolutely not. That wasn't allowed. And we wound up going to court, and the judge said, well, why can't you just program it to disclose disclosable fields? That became the end of the lawsuit. But that was 4 years later.
Right. I'll just note on the portals that my agency has had a portal for about 6 years now, and we get 75% of our incoming requests through that online portal. And that's great. It makes life easy in some ways, but we do still take requests by fax and FedEx and overnight. And actually, we now get so few by fax and mail that sometimes those almost end up getting logged faster, because anything that comes in today by mail or fax is going to get logged on Monday, whereas we get so many more through the online submission that it actually takes a few days to get to them. So, while I understand, and we have had a couple situations where people have called and said, something's going on, we can't figure out what it is. And sometimes it's like, just fax it over and we'll try to figure out the problem. In the meantime, let's get your request moving. Don't get so frustrated with the technological issue that we don't get your request in the door. So sometimes you just might have to go the old-fashioned route. But do notify. We sometimes don't know if there's a problem. So it's helpful if someone can call us and say something seems to be wrong.
Do you ever get complaints from within the agency of it's much too easy to make requests? Because we hear out on the outside, especially when you're talking with the states and foreign countries that are setting up systems anew, and you say, well, best practices ought to be to have electronic ability to make requests, and they say, oh, no, it's too easy. Yeah, right. I mean, is that something that...
That's not something we're hearing. Well, I'm sure everyone would love to get fewer than the 10,000 requests we get every year. Yeah. At the FDA, I'm not hearing that as just sort of a, it is...
You're used to it, yeah.
It's more topical, Tom. I think dealing with folks who, work on a certain thing, they can ask for this?
Yes. That's
not the mechanism, but the this? Yeah,
right.
Sure, yes.
Hi, I'm Dan. I work for a smaller component of DOJ. I manage the FOIA program for my component. And I'm just going back to the discussion about searching and appeals on searches. And I find myself responding to or giving the background on appeals, describing our search. And I'm wondering if the committee, do they look outside government, or do they ask outside of government agencies in their process regarding searches? Like, would they, for example, maybe look to the American Library Association and reference librarian skills for asking questions about search practices? And if FOIA professionals might use some of those ALA reference interview skills, maybe that might help on the back, it might cut down on litigation and appeals on searches. So that's my question. I wonder, would the committee consider looking outside government agencies for skills and things like that? Guidelines.
I don't know if you want
I mean, I think it's a great suggestion. We didn't look at it on this prior term of the committee.
I wrote it down.
So we'll take it for the next committee.
For the next committee.
Have them focus on it. I mean, I think that's a great idea. I think we were just focused inward on the government to try to assess where we were, and we had trouble even doing that before going outside because, as you know, some agencies have centralized, some have decentralized. So in one agency, you could be talking about training 10,000 people because 10,000 people are responsible for research, and another agency, maybe 10 people. But I think that's a great idea for the next committee to take on.
Yeah, the one area where we did get outside input was on electronic searches, discovery. We had legal presentation on how in court discovery of large quantities of electronic records, you can use algorithms and AT and all this sort of stuff to be able to facilitate the search, which probably is not that applicable in most agencies. But the fact that it can be done now, I mean, it's very expensive still, but it can be done to get you through, millions of records.
I would love to see OIP maybe do a training for agencies just on best practices with searches and things like documenting your administrative record on a no records response. We at our agency have tried to do a lot of that. If someone's going to say we don't have any records, it's got to be documented on a form in a certain way and things like that. But your idea is something that could absolutely be part of that, because getting an appeal on a no records response or on a search issue and then finding out that, well, we don't know what was done, so now we have to start over is very frustrating.
All right, I'm sorry. Yes, please.
Hi, I'm Joshua Eaton, investigative reporter with Think Progress. I asked this question with the Department of Defense in mind, but I imagine it's an issue other large agencies as well. And that's where you have sort of a large, complicated agency with decentralized FOIA offices, and you end up having to make 10 phone calls and send a request 4 places and wait 2 months just before you get in the right office. And it can be for a record you know exists, you just don't know necessarily what subcomponent maintains that record. I was wondering if you see that as an issue and kind of what a way forward on that is.
Yeah, I mean, it was definitely for the best practices in terms of efficiency and resources. One of the things that we recommended was, whenever possible, centralize both processing, but also the records themselves, so that they can be searched more easily and more broadly without having to do these kinds of multiple requests or this kind of round robin where it keeps getting forwarded and some component says, well, that's not us. We're going to send you to who we think has it. And then they get the request and they say, no, it's not us either. And I don't know that we addressed those kinds of consultations or I'm forgetting the term for when they forward it. Referrals. Thank you. So maybe those are something we could look at, or depending on what the next round looks at, could look at those.
Anecdotally, I see that happen all the time, and I think it's because FOIA offices are siloed and not necessarily in the business of doing the agency mission. So I think Sarah, something mentioned earlier was having folks rotate in and out from the mission of the agency into the FOIA office. Having that would probably reduce that. I mean, I had a DoD issue this week where folks wanted to send something to Africa Command. I took a look at it and said, that's Europe Command. Africa Command didn't exist when this document, blah, blah, blah. And they said, oh, how'd you know that? And I said, I don't know. I knew. So having that knowledge shared in the FOIA office would probably resolve that, but I think it happens across agencies all the time.
And it happens to us, too. When we find it just as frustrating as you do when someone says to me, oh, we're going to actually have to refer this to the Department of Justice. And I'm like, what part? And then they say, well, I think it's the Civil Rights Division. Then I have to, call 8 different people to find out, because I don't want to send your request to the wrong person. Then I've taken part in kind of making your life more difficult. But we sometimes, because these agencies are so big, and we understand our own usually, it is just as frustrating for us as FOIA officers as it can be. And sometimes I'm very sympathetic to those who don't even have like a government experience. Sometimes I'm like, okay, now I'm facing the bureaucracy and I'm part of it. So I definitely understand where you're coming from. I think having centralized points of receipt is important, and having people who do what we call triaging of FOIA requests, who are very knowledgeable about your agency, or particularly if you're a department, the FDA is not a cabinet level agency, but I can understand at places like defense, that would be very difficult, and maybe that's something like for whoever gets there, whatever point of receipt they have there, to make sure that those people are best trained to understand what goes where, understanding that some requests, I mean, I've been at the FDA for 15 years, I can look at a request and go, I have no idea what that is. Sometimes you just don't, but I would say the vast majority of requests, people should really know where it's going to go.
You know, I think that OIP has a guidance on that subject a few years ago that refers, that comes back to one of my favorites, keeping the requester informed about what's happening inside, so that you're not just sitting there staring at a black hole while, you know, the agencies are referring, and for good reason, because sometimes it's not clear. The requester probably couldn't have found out, you know, on your own which of the places to go, and officials like Sarah are doing you yeoman service to try to find out and make the phone calls and figure out what to do it. But making that call back to say, the reason this is taking so long is because we don't believe we're the right place, and we've referred this to such and such. And now the separate question comes up about when the receiving agency then says, you know, we're not going to answer that one, or doesn't respond even to the referring agency. That's a separate set of issues. But I think that informing the requester along the way is clearly important.
I do want to give a shout out to DOD to the extent that they recently issued one unified set of FOIA regulations, and we're seeing now all the subcomponents rescinding their FOIA regulations. So I feel like at least they're, you know, going in the right direction to try to at least achieve that through a centralized FOIA reg. So I think that's helpful.
That's great.
All right, well, I want to thank every single one of our panel members. It's been really informative and hopefully fun for you. And I hope you'll come back and consider being on the next term. There's still time to nominate yourselves till June 1st. No pressure. Thank you, everyone, for listening to us so politely, and we really appreciate your time.
Thank you.
You know, I learn something new every time I'm on one of these panels. It really is kind of fun.
So before we wrap up, and I know folks are already packing up, I just do want to have a chance to give public comment opportunity to anyone in our audience, or if anyone on live stream has made any comments. No? Kirsten says no. Anyone have any other thoughts they want to share? Oh, Rick. Rick is back.
I just wanted to make three quick points. I'm just to reintroduce myself. I'm Rick Bloom with the Reporters Committee for Freedom of the Press. One is on advisory opinions. I know Tom mentioned the efficiencies of OGIS being able to provide advice, and it was a part of the original view of how the office should operate, mediate specific cases, look at the system as a whole, and I think that's kind of a big gap. And I know people have heard me say this, so anything you can do, I know you've put some work into it, just have a non-zero number when you report to Congress, and hopefully non-one number when you report to Congress on the number of advisory opinions you've done, I think would be really great. The second thing is on this issue around the Privacy Act and getting SORNS notices out from agencies for OGIS to be able to actually see the request when there's a dispute. It's a ridiculous interpretation in our view. OGIS should be able to see the records and have responsibilities and fulfill its obligations. So I know Congress is working on that solution. If there's any way we can help within the executive branch just to resolve this, I think would be we'd be happy to follow up. And then I just echo Tom's comment about the OMB fee guidance, since that was updated in the 2016 FOIA amendments. I think Congress was serious about that being implemented. So that's it. Thank you.
Thank you very much. Anyone else? All right. Well, thank you again for joining us today. Everyone gets a break. You get to leave a little early. Enjoy the rain. Hopefully it'll come to an end by the end of the weekend, and have a great weekend. Thanks, everyone.